Mr. Vasquez, you've got Luther Sharp.
He thought the cap protected him. The judge said he don't have to give you 15 one more mistake. And it gets worse.
Are we just going on one?
Yes, Your Honor, we're going to dismiss. Make sure I got the numbers right.
Ma'am? I'll bail.
0917,
Good morning, sir. Are you Luther Sharp?
Yes, ma'am.
Mr. Vasquez, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Sharp, in cause number 25, wait, are we going on count one?
Count one, Your Honor.
All right, hold on. Let me get that done. Okay, in 25 DCCR 0916, the state has elected to proceed on count one only. It alleges that you committed the second-degree felony offense of aggravated assault with a deadly weapon from May 26th of 2025, and how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Vasquez?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 15 years in prison, which means you're leaving your punishment up to me. And as long as I don't give you more than 15 years in prison, you can't appeal that. I can give you 15, I can give you less. It'll all be determined on the evidence and information that I receive at a sentencing hearing.
Yes, ma'am.
You have an absolute right to have a jury come in and do two things. The first is to determine if you're guilty or not. And then the second is, if they find you guilty, then you could leave your punishment up to them. If we go forward this way, you're waiving that right, and is that what you want to do?
Yes, ma'am.
Also, part of that agreement is that the state would dismiss cause number 25. Y'all wrote C, but I think you meant DCCR.
That's correct, Judge.
DCCR 0917. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Sharp is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for a sentencing hearing, and so the probation department can do a pre-sentence report. We'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Vasquez, and he'll present it to me on your behalf when we come back.
Yes, ma'am.
All right, you can go back with the bailiff.
Your Honor, can I speak?
Sure.
Would the court consider a bond reduction?
Not with a cap of 15 years in prison. No. You can go back with the bailiff.
Really? Stupid questions. Consider being you think about it about 3 seconds.
Well, I guess, yeah, I could have thought about it for a little bit longer, but thanks for asking, but no. Oh, you know what? Bring him back out here. Enter him.
5 seconds? Yeah, it's too late for that.
I figured shooting somebody.
Mr. Sharp, I want to make sure that you understand and know that I receive, the district attorney's office receives, your attorney will receive all of your disciplinary incident reports from the jail. I have 11 pages of them. So if you think you're going to come in and ask me for any type of consideration on that plea, my suggestion is between now and when you come back, I don't have any more added to this.
Yes, ma'am.
I don't have to take the 15 years.
Yes, ma'am.
We could go to trial, you could get worse.
Yes, ma'am.
A jury will see all of this.
Yes, ma'am.
You're too old for this nonsense.
Yes, ma'am.
All right, go back with the bailiff.
Thank you, Judge.
At least I didn't go through what he was doing. So icky. Miss Holmes, on Robert Lowe, sentencing.
Robert Lowe. I guess I didn't see it.
I don't like it.
I don't, when they did, I don't
Okay.
think they gave somebody for stuff.
Yeah. I don't think.
I'm all right with it.
All right, are you Robert Lowe? And so Mr. Lowe was previously in court, entered pleas of guilty to 3 cases of possession of child pornography. There was an agreement in those 3 cases for a 7-year deferred probation and a $1,000 fine with dismissals, I think, in 3 or 4 other cases. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
I feel like this is different from some of these types of cases, because Mr. Lowe was actually involved in creating with his own family member victim, who was very young, 5 years old. So this wasn't I downloaded something and didn't realize what I was downloading. This is very different. This is a family member that was victimized because of this. Don't talk right now, okay? And so for those reasons, I do not feel comfortable accepting deferred probations in these cases. So I'm going to reject those plea offers. I don't know, honestly, I haven't thought more about what I would be amenable to other than potentially just letting a jury decide. I'll reset it one time. You guys negotiate, see where you are on it. And if you come up with something, you can contact me. Otherwise, we'll get rejections and get his cases set for trial and let a jury decide one way or the other. Okay? I'm just not comfortable with this at all. You can go back with the bailiff.
But I already signed for probation.
I don't have to accept your probation.
I wasn't told that.
Yeah, you actually were, because we reset your case for sentencing. And here's the thing. It doesn't matter if you were or not. I'm not accepting the plea agreements. Okay?
There's
nothing you can do at this point other than Ms. Holmes will be out there to visit with you about any other options. And if you don't like those options, or if I don't like those options, then ultimately that's what a jury is for. If everyone can't agree, and then we get a jury to come in and determine if you're guilty and what the punishment is if you are found guilty. Okay? So let's see where we're. I'm not going to consider any bonds at this time.
Yes, Your Honor. I just, his mother is here, and so, but just for the record, because I have spoken with her on several occasions, as well as with Mr. Lowe. They did keep asking me if he would get out today, and my response to both of them was that it's up to the judge. At the
Okay.
end of the day. So
Thank you,
I
Ms.
told you
Holmes.
that yesterday
Yes, ma'am.
when I visited with you,
Yes, ma'am.
and I told that to your mother.
Yes,
That
ma'am.
ultimately it's up to the court on whether you would be released today and placed on probation.
Yes, ma'am.
Thank you, Ms. Holmes. You can go back with the bailiff.
I can't say nothing else.
It's probably not wise right now, okay? Go back with the bailiff. I'm going to delete the other dismissals that came through at this time. All right, Ms. Holmes, on John Dre Willis, there's no paperwork on this, right?
Not today.
Okay. Let's get Mr. Willis.
Really, I tried, I didn't get a response.
I make you felony probation. Put this on this, so that we can get a good sign. And maybe the same conditions.
Good morning, you're John Dre Willis. And this is 25 DCCR 1048. Mr. Willis is charged with burglary of a habitation. What is the announcement?
Judge, I can, if you,
Okay.
he was here on October 21st. The complainant in this case had signed a non-prosecution affidavit. She came to court that day, and during the pendency of the court process, she got my attention. We went to the back, and she said, I changed my mind. I don't want to do it. I want him to be held some kind of responsible. Based on that fact, I took that non-prosecution affidavit, kind of out of the equation, and the court imposed the bond conditions by agreement
Yeah.
that the bond would be reduced at $7,500. He was to have no contact with her or GPS, and he had to go and live with his mom in Iberia.
Correct.
And we have the address. He has obviously not made that bond in the interim 6 weeks or so. She has not reached back out to me, but in light of that fact, I don't feel comfortable making the offer that has been requested for a misdemeanor. I would be willing to offer a felony probation with the same conditions pending a PSI. I just think a PSI would be important. I've tried to call her this morning with no answer. I can either make that offer pending a PSI, or I could ask you for 1 week and see if I can get a hold of her. I just don't want her to feel blindsided by it because she's gone back and forth. I'm not saying that she hasn't gone back and forth, but I think there needs to be some things in place. There was also a gun involved. We were able to determine that she actually found it, and it was not as big of an issue as we had initially thought, which is why my willingness to make the felony probation offer. I just think that's in my best interest.
So why don't we do this? I mean, I did reduce that bond. I found that. Let's reset it to next Tuesday. See if you can get in touch with her. If that changes anything with regard to any agreements, and if it doesn't, then I would potentially reconsider that bond number to something that he was able to make with those same conditions. I think that would be proper for everyone's safety, but we could make the same conditions with the lower bond. So let's reset it to next Tuesday, and we'll see what the state finds out. Okay? We'll see y'all next week. Number 25, DCCR 1254, Mr. Williams, come back up, please, sir. Okay, you're Derek Williams. And Mr. Lewis, will your client waive the formal reading of the indictment?
He does, yes.
So we're going to go through the indictment again because it's required. Mr. Williams, you're charged with the state jail felony offense of evading arrest or detention with previous convictions. And that is from August 14th of 2025. The indictment alleges you were previously convicted of evading detention June 4th of 2007. It further alleges that you were convicted of burglary of a habitation with intent to commit theft, a second-degree felony, February 1st of 2006. And after that was final, you were convicted of aggravated assault with a deadly weapon, a second-degree felony, December 10th of 2009. How do you plead to that charge? And are those prior convictions true? And did you enter your plea of guilty and true, freely and voluntarily? And because you actually did what they've charged you with. I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them?
I do.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Williams is not competent?
No.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of evading arrest or detention with previous convictions. Find those other 2 prior offenses true. Sentence you in accordance with your agreement to a term of 4 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. Good luck to you, sir. You can go back with the bailiff.
The deal wasn't mercy, it was